on legal developments in 2017. We all know that businesses that want to invest in our country look at rule of law to protect their rights and interests. Therefore, it is important for our country to regularly and consistently send out a message that there is rule of law in India. The Indian judiciary has time and again been sending out that message, and the year 2017 has been no different. The Delhi High Court in the True City 1 Mauritius Holdings versus Unitech Limited dismissed the plea of Unitech Limited, challenging the award of the London Court of International Arbitration on the basis that the award, after you have entered into a contract, knowing the regulations and intending it to be legally enforceable. Similarly, in the Tata Docomo matter, where the parties amongst themselves had reached an agreement to make the payment, but the Reserve Bank of India intervened of the Indian Exchange Control Regulations. The Delhi High Court once again dismissed the plea of the Reserve Bank of India on the basis that the Reserve Bank of India was not a party to the arbitration agreement and it has no locus to challenge an award passed by the London Court of International Arbitration. The Government of India has also taken several steps in the year 2017 to develop a more conducive business environment. Non-compliance of laws, internal mismanagement, lack of corporate governance are all issues that cause concerns to investors. The government has taken significant steps in the year 2017 to address some of those issues. You may have noticed in the news reports that the government has taken a decision to strike off almost 2 lakh companies from the register of companies. They have also disqualified almost 3 lakh directors, and the news report suggests that there will be a the striking off of almost 1.2 lakhs more companies on the grounds of non-compliance with Indian law and for not carrying on business for a long period of time. The government has also notified rules for restricting the number of layers of subsidiaries of Indian companies. The intention has been to prevent misuse of multiple layers of subsidiaries for diversion of funds and for siphoning off of funds from Indian companies and for protecting minority interests. The Indian companies law already restricted Indian companies from investing by more than 2 layers of Indian companies, but now the rules completely prohibit Indian companies from having more than 2 layers of subsidiaries, subject to certain exceptions, one being that the entity itself and 1 level step down subsidiary is not considered in the 2 layers of the subsidiaries beyond which further subsidiaries cannot be created. The Benami transaction rules have also been amended, which are set out under the Companies Act regarding the Benami ownership of shares of Indian companies. The government has tightened the provisions. In doing so, it has amended the definition of the term beneficial ownership, which triggers disclosure requirements, and have imposed new requirements on individuals holding substantial interest or ownership interest or substantial control on Indian companies and requiring them to make disclosures. India stepped up in ease of doing business rankings and have gone up by almost 30 ranks. Has the government done something in 2017 that made this possible, and has the government been doing something after that to improve ease of doing business in India? A large part has to do with ease of setting up business in India. The government has modified the rules and regulations time and again in the year 2017, trying to make it easier and easier to incorporate a company in India. If you compare it to the counterparts, the Western jurisdictions, the more developed jurisdictions, in India, incorporation of a company was a time-consuming process, and even after incorporating a company, it required significant registrations and approvals to even start the initial processes. For example, to even open a bank account, you required a PAN registration. The government in the year 2017 came up with a SPICE e-form, which allows an entity to incorporate a company, reserve the name for the company, as well as get the PAN and the TAN registration in the same process. And the objective is to make it possible in 1 day. For the foreign investors, the government has abolished Foreign Investment Promotion Board in the year 2017, and the portal of Foreign Investment Board Promotion Board has been replaced with or renamed as Foreign Investment Facilitation Portal. Now the applications for FDI in the sectors which are covered under the government approval route are taken up directly by the individual government departments or individual government ministries, and therefore effectively removing one step from the process. The government has also notified the standard operating procedures pursuant to which now the ministries looking at applications for foreign investments have to approve them or convey a final decision in a time-bound manner. The government has also tried to make it reduce the number of compliances that are required to be undertaken by companies doing business on an ongoing basis. One example of that would be the labor and employment legislations. There were about 56 registrations and forms that were required to be maintained by companies under almost 9 central labor and employment legislations. The government last year realized that in all those registers and forms there were lots of overlapping entries, and therefore it was unnecessary for them to be maintaining so many different forms and registers. The government notified the ease of compliance rules pursuant to which those 56 forms and registers have now been reduced to only 5 forms and registers. Of course, there was GST last year, which we understand have not been considered in the ease of doing business rankings, and certainly while it has its own challenges, it is certainly a step towards making it easy doing business in India. And government continues to do a lot more things in the year 2018. I acknowledge that this may not be a complete summary of all the changes that have happened in the year 2018, and if you would like to, if you have any questions or you would like our views on anything else, please feel free to post your comment in the comment section below. There are some questions that we have received from the audience before we started the webinar. The first question is, what are the key takeaways from Gujarat NRE insolvency decision? The Gujarat NRE insolvency decision, the judgment dealt with a situation where the insolvency plan was not approved by the resolution plan was not approved by the committee of creditors within the statutory time period of 180 plus 90 days. The employees of the company had made had come up with a suggestion for the resolution plan, but they came up with the resolution plan suggestion very late, just about a day or two before the expiry of the time period within which the creditors committee had to approve the resolution plan. The National Company Law Tribunal did not grant any extension of time and ordered liquidation. I think the key takeaway from this decision is that the National Company Law Tribunal is going to honor the timeline set out by the statute. It is not going to entertain any applications for extension of time periods, which I would say is a welcome development. The other interesting element of this case was that the National Company Law Tribunal ordered a slump sale of the business of the company in liquidation on a going concern basis, and this also shows that the National Company Law Tribunal will not shy away from exercising its discretionary powers to come out with innovative solutions to resolve issues. And they have in the year and they in this case went ahead and ordered a slump sale, which will in this particular case fetch a better value and will be beneficial for the employees, who will not lose their livelihood since the transfer will be on a ongoing slump sale basis. The second question we have received is how would the recent cabinet approvals on FDI policy impact crucial sectors like aviation, pharma and construction development? In the aviation sector, the FDI policy restricted investments up to 49% and under the government route. And the only exception was Air India, where foreign direct investment was not permitted. The government has modified the policy to allow foreign direct investment in Air India up to 49% under government approval route, and with certain restrictions with respect to ownership and effective control management. Now the purpose of this change seems to be, and it gives an impression that the government is still serious about disinvestment in Air India. In the pharmaceutical sector, the government has permitted a wide range of items that can attract, and in the medical devices specifically, they have permitted a wide range of medical devices that can attract up to 100% FDI via automatic route. And this will certainly benefit health services in the country, as India will gain access to new modern equipment and machineries. In the real estate, there is a clarification which has been added in the FDI policy to allow up to 100% FDI in real estate brokering services. Now, and they basically clarified that it does not amount to real estate business, because real estate business, the FDI is restricted in real estate. Effectively now in real estate brokering services, FDI will be 100% permitted. But we understand that there are already real estate, foreign investments in real estate brokering services in India on the basis, and the understanding earlier was that it is covered under services sector. So this will more be in the nature of a clarification rather than a far-reaching change. Thank you so much.